Factors that the court determines how they're going to look at child conservatorship, and a lot of people get mixed up with I want full custody or I want custody of my child. It's really conservatorship, possession and access, and child support, and the conservatorship portion is always determined upon whether or not there's some sort of danger to a child. If there's a danger to a child, then the judge can make a decision that one parent or the other parent is going to be the sole managing conservator. But in most cases, parents are good people and they're good to their children, so there will be a joint managing conservator, and as the family code states, whether it's right or wrong, there's a primary parent and then there is a non-custodial parent who where the child goes and visits. And in those cases, you have child support that's paid, and the judge will take into consideration many factors on what the possession and access schedule is. Just because there's a primary parent doesn't mean we're not going to have 50-50 possession and access, a week on, week off, or some other type of possession and access schedule. But many times the court is only able to go within the confines of the family code to appoint a primary parent and then have the non-custodial parent have a standard or expanded standard possession schedule, which many people ask all the time, what is a standard or expanded standard possession schedule? And under the family code, for someone during the school year that has a standard possession order, they're going to pick up their child on first, third, and fifth Fridays of the month at 6 p.m. and they're going to return the child at 6 p.m. on that immediately following Sunday. And they get every Thursday during the school year from 6 to 8 p.m. And they also get 30 days in the summer. They get every other spring break. They'll also get every other Thanksgiving and every other Christmas. And sometimes the court will allow for a parent who's a non-custodial to have an expanded standard. And the only thing that changes is during the school year. They get to pick up their child on Thursdays at school and return their child Friday morning. And then on the first, third, fifth weekends, they get to pick up their child from school on Friday, and they'll return their child generally on Monday morning unless the judge limits it back to 6 p.m. on that Sunday. But there is no set conservatorship method or conservatorship model that the judges go by. It's all dictated by the facts that are presented to the court, and they vary. As I said, it's like a fingerprint or a thumbprint. Joint managed conservatorship is what most cases fall under, where their child is not in any type of danger. But if there are facts presented and there is a necessity for a sole managing conservatorship, the sole managing conservator will have the right to make medical, dental, and surgical procedures that are invasive in nature. They'll make psychological and psychiatric decisions along with education decisions for the child, and the other parent doesn't have that right because there have been facts presented, whether it's maybe the parent has had a drug issue in the past or a criminal history in the past or endangered children in the past. The judge can make a decision on conservatorship being a sole managing. But if it's not sole managing, then the parents will generally share those those rights and duties jointly, and one will generally have a trump card, if you will, with after a consult they get to make the end decision. But for the most part, the courts are attempting to put both parents on an even playing field so everybody knows what's going on with their child. That's the most important thing, is no parent wants to be left out of their child's life or decisions that are made.